and welcome to the Arbitration Conversation. So in this webisode, we're going to be talking to a true leader from Canada, Professor Josh Karton. Josh has been a professor of arbitration for many years. He's an associate professor and associate dean for graduate studies and research at Queen's University faculty in Ottawa, Canada. And he writes about international dispute resolution, especially international arbitration. He's been heavily involved in several high-profile projects in Canada, including the new Canadian Journal of Commercial Arbitration. So I'm really happy to have Josh with us. He is definitely a leader also in comparative law, and he's done work in Europe, and we're going to be able to talk about his legal project that he's working on right now. So first of all, Josh, thank you for being here.
Thank you, Amy. I was flattered by the invitation. I'm excited to talk to you.
So first of all, could you tell us a little bit about the journal? What was the vision? How it's come to be?
It's, the truth is the vision started with Juris, the legal publishing company. Although the way things have evolved, we're kind of running it on our own, although the journal is made available through Juris's online database. But basically, it's the people there who noticed that there was a gap, and there was kind of an opportunity for a commercial arbitration journal in Canada. And we're trying to kind of fill the sweet spot between the more academically oriented journals, which exist and some are very high quality in Canada, including some focused on dispute resolution, and the practitioner-oriented publications, which tend to be, I don't mean this as a denigration, but they tend to be glorified newsletters. And the articles tend to be no more than a few pages, focused on recent developments, important new cases, and the like. So we're trying to really bridge that gap between the two and bring some academic depth and rigor to the publication, but have it also be something that practitioners can really use in their day-to-day work as well. We just officially launched in June. We have a team of senior editors who are all leading practitioners and academics from across Canada. I'm the youngest. I'm the baby of the team and the managing editor doing most of the grunt work. And then we have a really stellar editorial advisory board composed of nearly all of the leading figures in international arbitration in Canada, including Canadian expats who are long-term practitioners in other cities and other countries.
So yeah, I want to be sure that everybody knows where they are able to get this. So just to tell the audience, where exactly can they get their hands on this new journal?
So the journal is also sponsored by my home institution, the Queen's Faculty of Law. And so the journal website is housed by Queen's. It's cjca.queensu.ca, cjca.queenslaw.ca. And the first issue, the inaugural journal that dropped in June, is available free in full on that website. We also have a blog that is largely sort of case comments and recent developments that we try to keep things fresh. We only have 2 issues a year of the main print journal. So you can get the inaugural issue free at cjca.queenslaw.ca and also read our blog. And you'll be able to get all of the issues on Juris's arbitrationlaw.com online platform, which is a subscription platform that has a pretty international reach.
Oh yeah, absolutely. Well, that's very, very cool. I'll have to check that out. I look forward to subscribing and being able to read the different articles that are there. I guess I also wanted to get a chance though to talk to you about this new project that you've been doing with Europe. Maybe you could tell us a little bit about it. I guess you described it as a socio-legal project, but could you give us a little bit better description of in-depth sort of the genesis of the project and what you're hoping to do with it?
It's something I'm really excited about. It is, so that the basic idea is to understand the profession of commercial arbitration across Europe. And we have what we're pretty sure is the largest research grant ever awarded for research on international arbitration or on commercial arbitration from the English, what's it called? The ESRC, Social and Economic Research Council, Social and Humanities Research Council, excuse me. The overall leader of the project is Tony Cole at the University of Leicester, but we have a really large and varied team, including lawyers from all over, sociologists, and psychologists. And the plan is to try to look at the profession of arbitration and then see how that affects the kind of justice that is delivered through the arbitration process. Since, as I'm sure anybody who's watching this knows, more and more commercial disputes are resolved through arbitration. And so it's increasingly, it's just a big part of the picture to understand how commercial disputes are resolved, and what are the legal processes and the legal outcomes.
But why did you,
oh, go right ahead,
yeah. Real quick, why did you decide, because you're in Canada, so why Europe, I guess, I just want.
Well, this actually grew out of a project that was funded by the European Union Parliament. It was originally a survey-based project that Tony was involved with, and other members of this research team, including Pietro Verlani and Barbara Barbas. And that sort of got us thinking about comparison of arbitration practice across Europe. I wasn't involved with that. But I have a background in socio-legal research, and that really goes back to, well, especially to my PhD. And my PhD thesis then yielded a book called The Culture of International Arbitration and the Evolution of Contract Law, which was not only an interview-based project, but I think kind of established me as someone who could conduct interview-based research in arbitration. And I have a connection with Tony going back several years. He also has a very strong interest in socio-legal research and in psychological research on arbitration and on dispute resolution. So he invited me to join the project, is really how I got involved. And since it's European funded, it's got a European focus. But it's really socio-legal research on a scale that is rarely possible due to the extraordinary funding we have, over £1 million British pounds. So in the end, we're covering 53 countries, every country that's in the Council of Europe. We're going to be conducting several hundred interviews over those 53 countries in about 200 cities.
That's really cool. What kinds of questions
it's just massive.
Yeah, I mean, that's really interesting. I've done a lot of some interviewing type research in contract law, and it's very sort of elucidating to get this information. What kinds of questions are you going to be asking through the course of this research?
Well, we have a set of them. Just to give the background, we completed a pilot study in Egypt. So we wanted a country with a thriving international arbitration community, but that's outside Europe as a comparator, where we could refine our question templates and our code books and so on. And I conducted those interviews together with Tony. But the grant agency isn't going to pay to fly me across the Atlantic for that many interviews. So he's pressing on his own. And we collect a variety of information. So some of it is demographic type information, which could also be conducted through a survey, but it's very effective, we found, with interviews to start with some kind of easy warm-up questions. It helps you build rapport. So one of the things that we're particularly interested in is what kind of background draws people into the arbitration profession, and what kind of background and skills are necessary for success within the profession. Because it's a sort of a personnel as policy type of perspective. If we know what kinds of people are involved, we'll know what kinds of processes they prefer, what kinds of justice is going to be produced by those processes. So we're looking at demographic things like age, gender, legal background, whether they have multi-system training, multilingualism, which is something that's sort of increasingly important for success in arbitration. So even as more and more arbitrations are conducted in English around the world, having that kind of cross-cultural sensitivity and ability to understand where people from different cultural backgrounds, different legal backgrounds are coming from is something that our preliminary data has shown is really appreciated by the international arbitration community. Every single interviewee in Egypt had been trained in the law of at least one other jurisdiction. Typically France, which is where a lot of Egyptian law is based, but also many of them had training in either American or English common law. And every single person we interviewed said that that was crucial, not just to kind of getting hired into an international arbitration practice group, but to actually being successful in the field. To have that kind of cosmopolitan perspective and ability to work across legal orders and across legal cultures. One of the other themes that we're interested in is kind of the role of diversity. Partly that's a question of who gets in, right? What do the gatekeepers of the profession see as acceptable, and who kind of moves up through the ranks of the profession, in particular to being appointed as an arbitrator. And the scope of the project allows us to go beyond the kind of core of the profession, the global elite that has been studied before in socio-legal projects. And this is something I'm guilty of myself, that my book really focused on that highly globalized elite. But we're able to move beyond that. So we've gone to half a dozen cities in the UK, not just London. We've gone to, I think, 8 cities in Italy, 4 in Sweden, 2 in Egypt, Cairo and Alexandria, to get a look at the profession beyond sort of the bold-faced names that appear in the who's who and the chambers and partners rankings, to see how arbitration is really being practiced on the ground. And so there's an interesting relationship between the local, the regional, and the global. And one of the things we found in our preliminary data, before the interviews got shut down by the pandemic, and we're kind of taking an opportunity to take stock before we're able to start them up again, is just how regionalized the profession is. So for example, our Egyptian interviewees, all of them practiced extensively across the Middle East, but they had very little work experience outside the Middle East, except for that handful of most prominent practitioners. And we've seen the same sorts of things in other areas. So you could look at an international arbitration practitioner in a city like Gothenburg, like Göteborg in Sweden, could have an entirely international practice, but almost all of it around the Baltic Sea.
Oh, interesting.
And not much beyond there. And it's those kinds of patterns, including a social network analysis that our sociologists on the team are performing, that we're able to bring out by doing this kind of research at a scale that it hasn't been done before.
Well, it'll be interesting once you sort of look across Europe to see if those same trends really play out, or if it's within the EU, or what is a quote unquote region, right? Region can be defined narrowly or broadly. And
the other interesting thing is, what we're going to look at is how much of this is related to legal families, right? So do lawyers from different countries tend to have disputes involving parties or seated in countries where they're part of the same legal family? Or are they about regional trade blocks? And geography, I think, is an underappreciated but very important force in setting up trade patterns. Canada and the US is a good example. We're each other's largest trading partners, and that's mostly just because we share the longest undefended border in the world. So is that what's driving it? Is it linguistic or cultural links that are driving it? We're not really sure. And because the Europe itself is so broadly defined, the Council of Europe countries includes all of the former Soviet republics, including the Central Asian republics. So that, again, we haven't had a chance to get there yet in the interviews. We're looking forward to it. But how much are they connected to, for example, the Russian International Arbitration Committee, or other parts of the former Soviet Union or Warsaw Pact trade blocs? How much do those relationships still shape commercial relationships and therefore commercial dispute resolution today?
So when do you sort of expect to have findings, or when are you hoping to conclude this project?
That's a fair question. It was envisioned as a 5-year project to begin with. It's now at least a 6-year project with COVID-related delays. We're just coming out with the first publications based on the Egyptian pilot study now. So I just had an article come out about a month ago from Mizzou's own Journal of Dispute Resolution that's mostly about comparative law practice within international arbitration, but I include a section with some findings from that Egyptian pilot study. And we have a few other papers coming out now. In terms of the final project, assuming that we're able to start conducting interviews again in 2021, we probably won't be able to complete them until 2023. And then it's such a large mass of data, we won't be able to really present the bulk of it until 2024 at the earliest. But we are trying to roll out some papers on discrete aspects of it in the meantime. So for example, on the some of the diversity aspects. We're able to get some preliminary data and write on that sooner rather than later. So within the next year, hopefully to have that come out.
Well, and on the diversity point, I mean, I would think the social networking front becomes particularly important. It is a pretty insular community, and who you know becomes incredibly important within the international arbitration field.
It's really true. We found it with the Egyptian interviews that there was actually quite a lot of at least gender diversity within the younger ranks. Right? We're trying to interview people everywhere from just a few years out of law school up to the most senior practitioners to get that breadth of experience. And there were a lot of very accomplished, very ambitious young women at some of these law firms who didn't feel that gender was really much of a factor holding them back. The middle-aged ones, the more senior women, definitely felt that, but the younger ones, not so much. However, they did still report that what really concerned them was finding a kind of patron or mentor in a more senior generation who could provide those introductions and help them build their connection network. And that perhaps despite the growth of international arbitration, from what Desiree and Garth once described as sort of the charming vocation of a few European diplomats to a big international profession, there is still that vital element of personal network.
Oh, 100. Well, and even then there's the final element of the client actually choosing that individual as the arbitrator. You can be a trained arbitrator, but never be selected.
Absolutely. So you were asking before about the kinds of questions we asked. One of the things that we've done is to pose scenarios to the interviewees and just ask them, well, if you were in this position, how would you react? One of those scenarios involved a hypothetical construction arbitration. We tried to choose an industry with a kind of a male connotation for the hypothetical. We want to say, well, the two co-arbitrators have proposed a female arbitrator as the chair. Your client, an old school, unreconstructed construction mogul, doesn't trust women in the construction and engineering business. How would you react? And just leave it very open-ended like that. To say, well, would you try to maybe convince your client to accept a highly qualified female chair of the tribunal? Or would you say, it's not my job. My job is to represent the client's interests. If the client says no, I have to communicate that no. And we got actually pretty varied answers to those kinds of questions. And at least with the comparatively small number of interviews we did in Egypt, we talked to about 40 people. Not a big enough sample size to see patterns about whether there's a generational difference or a gender difference or a background difference in how people navigate that. What I can say is that within the profession, even relatively senior practitioners said that they had never encountered that from another arbitration woman, and that they had only rarely encountered it from clients. So that's perhaps some good news.
Well, although you never know. I mean, one bias, you know, when people answer survey questions, they always want to sound better maybe than, they want to say they do things that look more positive than maybe what they actually do, which is one of the biggest criticisms of interview research.
Yes.
Because we don't know about the accuracy of people's reporting of what they would do, right, in a hypothetical situation.
It's a real problem, and it's particularly difficult to gather statistics about arbitration due to its decentralization, confidentiality, and so on. But we do want to try to leverage the statistics that are available to say, well, how much does the self-image of arbitration practitioners match the reality? As you mentioned, I mean, it's an inherent weakness of any kind of interview-based research.
Right.
Not necessarily that the interviewer is telling the interviewer what they think they want to hear, but that they want to present themselves in the best light possible. Mm-hmm. But I think there's also an opportunity there that's underappreciated, because I mean, the concern you cite is something that a lot of people worry about. Even survey-based research where it's anonymous, that still people want to present themselves as their best selves. But self-image is a powerful factor. And especially in a field like international arbitration, where there is so little by the way of rigid rules, where there's such a large menu of laws to choose from, there's so much flexibility. Self-image has a tendency to become reality. And so I think it's important, even just on its own to understand how members of the profession see themselves. But I think also in any profession, but especially one that's so flexible a field as international commercial arbitration, that self-perception has a way of actually shaping outcomes.
Right. Well, we can hope, especially in this area, but really interesting research. I mean, I'm looking forward to seeing all of it develop, because I do think getting a picture of sort of what's happening, and especially on the networking end, really interesting stuff. Be interesting to see how the reports develop, and a fun research project to be involved in. So congratulations for being part of it.
It's been so much fun.
Yeah, that would be so much fun.
You asked why Europe before. I mean, my own sort of language background, cultural interests are in Asia, especially in China. And I've got another project. We've applied for the grant. We're waiting to hear, because this kind of work really does require funding, that would do a similar kind of project across the culturally Chinese jurisdictions of Asia. So mainland China, Hong Kong, Macau, Taiwan, and Singapore, which have some common cultural links, although of course some diversity as well, but very different legal systems and legal backgrounds. And that provides a kind of a natural experiment where we can see, well, how much does that shared cultural background matter, or is it really all about the legal background?
Interesting. Well, listen, this has been really interesting. I'm looking forward to seeing how it develops, and thank you for telling us about the new journal out of Queen's, your university in Canada, and people will make sure to stay tuned and check that out. So Josh, thanks for taking this time with us today. I really, really appreciate it. Interesting projects. Definitely going to keep my eye out for them.
Thank you, Anna. I mean, every academic is excited to have a chance to talk about their research. It's what we live for. But this has been a great conversation.
It's great stuff. Great stuff. Thank you so much.
Thank you.